The Supreme Court is the highest court of the land for the state of Washington. In our system, federalist system, we have the federal courts and the state courts, and they're independent. So for any questions of Washington state law, our Constitution, our statutes, our common law, the Washington Supreme Court, the 9 justices on our court, have the final say on that interpretation. So the Supreme Court is the highest appellate court in the state of Washington. We have an intermediate court of appeals. It's been in existence in Washington since 1969. So when a losing party in the trial court wants to appeal, they normally go to the Court of Appeals. And then the state Supreme Court takes only those few cases that really have statewide significance. Maybe there's a disagreement among the courts at the Court of Appeals level. There's a significant constitutional question, or just a question of broad public import. There are a few specialized type of cases that come straight to the Supreme Court, but for the most part, it's a court of discretion, and here's only maybe 80 to 90 cases a year of the most significant questions that need to be settled by the highest court. We have one case this morning. That's the state of Washington versus Gators Custom Guns. Opening for the state will be Noah Purcell for 15 minutes, and then responding will be Austin Hatcher for 20 minutes, and then Mr. Purcell has reserved 5 minutes for rebuttal. Counsel, please proceed. When a case comes to the Supreme Court, all of the facts have been decided in the trial court. So we at the Supreme Court don't hear any witnesses, we don't determine any facts. We hear arguments of the parties.
Chief Justice Stephens, and may it please the court. Nothing in Washington's Constitution or the Second Amendment requires states to allow the sale of firearm accessories.
We look at the prior decisions of the court that address that legal issue, the precedents, and we consider how the law applies to those facts.
Yes, Your Honor, but in State v. CS, this court did recognize that the U.S. Constitution establishes a floor.
I firmly believe that the value of oral argument is the conversation that the attorney is having with the court. We have the briefing, we've prepared, we've read the cases, so we don't need just a presentation. We need an opportunity to drill down on some areas.
Of protections of rights.
Well, yes, but Counsel Jorgensen came right after that and basically adopted what it called middle-tier scrutiny, which I read as...
There are 9 justices on the Washington Supreme Court.
The court could have reviewed it at this time and made a finding, but wasn't asked to. Is that your position?
All 9 justices hear the case.
So what makes it something the state can't limit?
And then we discuss it. This case is now submitted and the court is adjourned. In private, among the justices, and talk about how the law ought to be decided as applied to that case. And it's a very democratic process. It takes 5 votes, a majority, for the case to be decided one way. And there might be a dissent. So there'll be a majority opinion and a dissenting opinion if not all 9 agree. And based on that vote, we assign the writing. Somebody's assigned to write the majority, maybe there's a dissent, maybe there are what we call concurring opinions, so they agree in the result, but they have different reasoning. Whether we're interpreting a statute written by the legislature, interpreting a written constitutional provision, or just interpreting legal principles, legal rules that have developed through case law, we're doing that in the context of cases. It's very important that we try to be true to the history, the development, and prior cases explaining those rules. And that's what we do call precedent. The Latin term is stare decisis, the rule of decision. And it's not to say that we never question prior rules. It's a human institution, and we see prior decisions that are just wrong. They reflect bias, they misunderstood some fundamental principles. But not only must we show that a precedent is wrong, we also have to show how it's harmful to the rule of law and maybe in broader ways as well before we will simply overturn it. And I think that's important that people understand we're a court. We're not just 9 people with our own ideas. We're here to interpret and apply the rule of law, and everyone is bound by the rule of law.
I represent the Office of Disciplinary Counsel in this matter. The primary outstanding issue remaining in this matter is the depositions
So completely separate from deciding the important cases that come to the Supreme Court, the Supreme Court also provides the rules that govern all of the lower courts across the state and the rules that govern who can be a lawyer, the ethical standards for both lawyers and judges, and other matters of procedure. So that tries to ensure, of course, the integrity of the legal profession and of the judicial system, and also uniformity in the rules of practice and procedure across the state. One thing Washington, as a Supreme Court, has long been a leader in is using the convening authority of the Supreme Court to bring together broad groups and focus on issues where the justice system has fallen short and where we need to make reforms and improvements. So we have one of the longest standing commissions on race issues, the Minority and Justice Commission.
Many scholars have drawn a through line between those foundations and systems that we exist in today.
For example, the commission did an extensive review about legal fines, so-called legal financial obligations, fines and fees, and a lot of reform came out of that, much of which was legislative reform that was then suggested by the judicial branch.
Speaking in support on behalf of the Superior Court Judges Association.
We've really centered voices of people who engage in the legal system and benefiting from their lived expertise.
And it's in the spirit of both hurt and hope that I stand before you.
And not assuming that those who work in the system have all the information or the knowledge about how what we do impacts people in their lives. I think one of the things that has come out in the ongoing work of our commissions is a recognition that just because we've always done something in a particular way doesn't mean it was actually fair, or that the burden of doing it fell equally on all people in our communities. So looking at how we can better make courts accessible, better allow people to be heard, that's really critically important.